Good afternoon, distinguished ladies and gentlemen. You're welcome to this edition of the AELEX Annual Lecture. Thanks for joining us this afternoon. I want to extend a very warm welcome to all of you on behalf of AELEX. We aim to start at 2 o'clock, and we would like to keep to time. So please, a lot of people are sitting on this side of the hall, so if you could just move towards the middle, and then we'll make some space for other people when they come in. Thank you very much. So registration is ongoing. There's water mains just to make everybody relaxed. Thank you very much. Okay, thank you very much. My name is Raymond Ofagbo. I am a senior associate at AELEX, the premier law firm in West Africa. And I'm going to be one of your MCs today. With me is my colleague.
Good afternoon, everyone. My name is Rehopa Jua, and thank you very much for joining us for this event. In the meantime, just to let you know, okay, thank you very much. In the meantime, just to assist you on knowing the directions in this place, I will let you know that on your right-hand side are the restrooms. So if you come out from this side, from this exit, the restroom is on your right, far down. And then these are the only exits. There are no fire drills today. So please, if you do hear any fire alarm, it is real. Thank you. We do hope that there will be no fire incidents anyways. And right about now, we would want to start the events, and at this point in time, we would like for the national anthem to be played. So please, could we all rise for the national anthem? Thank you very much.
Nigeria, we hail thee, our own dear native land. No tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland.
Okay, thank you very much. Could we all be seated, please? Thank you.
So once again, you're all welcome to this year's edition of the annual lecture. Like I said, we're going to start in time. The keynote speaker is already around, so please get settled in, get mints, get water, speak to the person next to you, meet somebody new, and as soon as the keynote speaker address, the keynote speaker is ready, then we'll start the program. So once again, welcome everybody. Good afternoon once again. For those of you that are not in the hall when I introduced myself earlier, my name is Raymond Ofagbo. I'm one of the two masters of the ceremony today. You're welcome. It promises to be a very, very impactful event. For those of you that have attended AELEX Annual Lectures in the past, you have an idea of what is in store. For those of you that are attending for the first time, I'm jealous of you because it's going to be a really mind-blowing experience. So welcome everybody. I see our discussants, keynote speaker are in, they are settled, and everything is set. So just a few more housekeeping rules. I know when we started, we had indicated that there were exits to the left and to the right of the hall, but just for the sake of orderliness, we would ask you to kindly indulge us, and if you want to leave in the middle of the session, to use the exit to my left, just so that it is not disruptive, and then we can leave this area free. This event is going to be streamed live for those of you that couldn't join us physically. It's going to be streamed live on LinkedIn, on Facebook, and on our YouTube page. So please encourage your colleagues and friends and family that are not able to join us to please tune in and follow the conversation. We also encourage you to amplify the conversation by tweeting about it, posting about it on your social media pages and handles. The hashtag for the event, like our Gen Z colleagues would say, is hashtag AELEX Annual Lecture. So welcome once again everybody. Now that we have the full ensemble, I would crave your indulgence for us to take the national anthem once again, just so that we follow due protocol. So please kindly join me, rise to your feet as we take the national anthem. Thank you. Thank you very much. You can take your seats, please. So we aim for efficiency today, so we would progress through our agenda really quickly. It's a packed lineup that we have. Some of the sessions are going to take maybe 20-40 minutes. We're aware that it's a busy afternoon, and we would like to get right into it. So we would like to kickstart the event with a brief welcome remark from a founding partner at AELEX, the head of our tax practice. So please join me in giving a resounding round of applause to Mr. Theophilus Emua as he comes to the stage to give his welcome remarks.
Your Excellency, distinguished ladies and gentlemen, a good afternoon to you all. This is the 19th in a series that we started many, many years ago. The idea at the time, and still is, was to generate conversation around themes that were relevant, first of all, to our profession, secondly, to the business community whom we serve, and lastly, to society at large. You will see in the program a list of some of our previous lectures, and you will find them of a wide spectrum of interests. We've talked about things like competition law, and this was early in the 2000s when BPE, for example, was privatizing many government facilities, and we thought to ourselves, well, at the way it is going, you will need to begin to think more and more of things like that, because if you've privatized 2 or 3 entities in the same industry, how they will relate with each other becomes more important. But when they were all owned by the government, it may not have been an issue. We looked at corporate governance. We invited the famous Mervyn King, who had authored the main work on the topic, and he came all the way from South Africa and gave us a presentation on corporate governance. We then looked at, for example, our power situation. At that time, Ghana was famed for having had 12 months of uninterrupted power supply in the city of Accra. So we invited the Minister of Power of Ghana to come and tell us how Ghana kept the lights on. Some of the things we learned from him, we're still trying to implement many years later, but I'm sure that we'll get there eventually. We talked about taxation without representation, because again, the civilian government was looking to raise revenue, and tax was one of the easiest ways to do so. And our host, Lagos State, was at the forefront of being proactive. The Attorney General of Lagos State is here in generating revenue. They went from a very low base to a very high number in a very short while. In fact, His Excellency was then the Attorney General, and he may be able to tell us how it was done. So these are some of the topics we touched on. Today we've decided to look at the rule of law and how it impacts the development of the economy. There are various thoughts on the point, but some people feel that if you don't pay attention to the rule of law, it discourages the growth of the business world. When I come to introduce today's keynote speaker, I will explain why he is probably the best person to tell us, speak on this topic. On that note, I'd like to say, welcome again, and we shall proceed to the next item on the agenda. Thank you.
Thank you very much, Mr. Emuwa, for that warm and very inspiring welcome. At this point, we'll proceed to the next item on the program, and this is where I will be inviting a very esteemed individual of one of Nigeria's leading Pan-African banks, and one of the pioneer banks we have in Nigeria. Obviously, we all know what I'm talking about. I'm talking about EcoBank, who has partnered with AELEX over the years. And for this, I would like to invite the Managing Director of EcoBank Nigeria, Mr. Bolaji Lawal. Please, a warm welcome for Mr. Bolaji Lawal. Thank you very much.
Your Excellency, good afternoon, sir. Distinguished ladies and gentlemen, we're delighted and we're honored to welcome you all here at our Pan-African Center. And most importantly, we're also happy to collaborate with AELEX regarding this lecture series. We align with the goals and objectives of this session because we're all looking at achieving a better legal system in Nigeria. We're looking at growth and ultimately a better Nigeria. So at EcoBank, we are also changing. We're exploring better ways to serve. We're exploring positive social impact. And ultimately, we hope that all this would achieve a better Nigeria for all of us. So we welcome you today. We hope that this session will educate us. We hope that it will inspire us. And most importantly, we believe that it will ignite the right conversations towards a better Nigeria. So I won't take too much of your time. Welcome, and we're happy to have you here. Thank you.
Thank you very much for those brief and really warm remarks, Mr. Lawal. I would like to invite the representative of His Excellency, the Executive Governor of Lagos State, Leonard Silk, Mr. Lawal Pedro, to deliver a few remarks on behalf of His Excellency. So.
Thank you. Your Excellency, my boss, distinguished ladies and gentlemen, let me extend Mr. Governor's apology for not being able to make it. He has so many functions all the way. We have the traditional rulers, some governors are also in Lagos. Well, I said I should represent him. So it's a pleasure to be here this afternoon at this prestigious annual lecture of AELEX, one of the leading law firms in Nigeria, and to join distinguished guests and eminent jurists here in reflecting on the subject that lies at the very heart of national transformation, the rule of law and economic development, the Nigerian experience. Permit me to express at the onset the warm felicitation of the government and people of Lagos State, to commend the organizers for sustaining this intellectual platform over the years as a space for critical conversations that shape our national consciousness and professional practice. The rule of law, as we all know, is not merely a lofty idea. It is the unseen infrastructure upon which every thriving society is built. It guarantees predictability, protects property, enforces contracts, and ensures that both government and the governed are accountable to the same set of rules. Where the law reigns supreme, order follows. Where justice is swift and impartial, business is flourished. When rights are respected and obligations are clear, investors gain confidence. But when the law is uncertain or inconsistently applied, growth stagnates, innovations declines, and trust erodes. The Nigerian experience has shown us both sides of the truth. If we look closely at our national journey, we'll find that some of our greatest strides in development have come when we strengthen our legal institution, when we reformed, when we clarified, and when we enforced. The liberalization of the telecommunication industry, the reforms in banking and company law, and the steady advancement of arbitration and mediation practice, all these were driven by law. Nowhere is this connection between law and development more evident than in Lagos State. As the commercial nerve center of Nigeria, indeed the fifth largest economy in Africa, Lagos has long recognized that sustainable growth depends on strong legal foundations. Our successes did not happen by chance. It is the outcome of deliberate policies, progressive law, and the bold judicial and institutional reform that have turned Lagos into a model of legal innovation. You will recall, on my assumption on second term in office, one of the summits organized by the government is the Justice Reform Summit with the theme, Administration of Justice for Economic Growth and Investment Protection. Just this year, we commissioned a commercial division of the High Court of Lagos State dedicated to handling complex commercial disputes, revenue, and investment-related matters. This is to ensure such cases are determined expeditiously by judges with deep expertise in commercial law, in resulting in decisions that are not only fair, but commercially sound and globally respected. Today, Lagos remains a preferred destination for investors, not because of its size, either population or otherwise, but because of its reliability. Investors know that Lagos is governed by laws, not by whims. They know that contracts will be enforced, disputes will be resolved efficiently, and justice will be served without fear or favor. That is the power of the rule of law. However, the government has observed with great concern the troubling pattern of sentiments, emotions, and sometimes blackmail that usually follows demand of our people for compliance with the rule of law. I therefore wish to use this opportunity to appeal to residents and to encourage them to comply voluntarily with our laws. Voluntary compliance with laws and regulations of the state, such as environmental, physical planning, income tax, land use charges, etc., and not wait for coercive power of enforcement of the law with the attendant consequences. Please let us reaffirm our collective commitment to the enduring truth that the rule of law is the foundation of every civilized society. As we consider the Nigerian experience, it becomes clear that the rule of law is not just an abstract concept, it is an economic asset. It is the silent engine that powers stability, productivity, and prosperity. To build Nigeria of our dreams, we must continue to strengthen the institutions that uphold the rule of law, ensure consistency in policy, and guarantee that no one, no matter how powerful, is above the law. On behalf of the government and people of Lagos State, I thank AELEX for providing this platform for such an important conversation. May our collective commitment to justice, fairness, and good governance continue to lay the foundation for a stronger, more prosperous Lagos and more prosperous Nigeria. I thank you for listening. Thank you.
Thank you very much, Honorable Attorney General of Lagos State. And many, many thanks on behalf of AELEX, many thanks to His Excellency for ensuring his due representation at this event. Our next speaker is someone very distinguished, a very delectable individual. There are so many feathers in his cap. There is hardly any room for more. It is not a mean task to properly introduce the speaker, like our keynote speaker for today. And so I would like to entrust the duty to a partner at AELEX, Mr. Theophilus Emuwa. Please make welcome Mr. Theophilus Emuwa to introduce the next speaker, who is our distinguished keynote speaker. Thank you.
Thank you. Good afternoon once again, Your Excellency, distinguished ladies and gentlemen. Our keynote speaker today is a man of many parts, but I will start from his secondary school career. He attended Igbobi College, Lagos, which at the time was one of the best schools in Lagos. I will not concede that it was the best because I attended another one, and maybe over drinks later we can debate which which was which. But he performed spectacularly well at Ibobi College, won many prizes. He then proceeded to the University of Lagos for his first degree in law. Again, he performed very well. After the youth service, he went to the London School of Economics for a master's in law. In those days, universities used to recruit the best minds for their faculties. So University of Lagos immediately snapped him up, and he became a lecturer at UNILAG. And he was there for a number of years when Prince Bola Ajibola became Attorney General of the Federation, and he needed some sharp minds, and he snapped him up again as a senior special advisor. Many of you may not remember some of the legislation that was introduced by Prince Bola Ajibola, but the engine room that crafted those things were driven by His Excellency and one of his other colleagues at the time. For example, the Companies and Allied Matters Act of 1990, which it's now been replaced by the one of 2020, but that was the first time that registry was being reorganized. Before then, the Companies Registry was somewhere on Oil Mill Street in Lagos. To incorporate a company was a Herculean task. To obtain information about a company was an equally Herculean task. Documents were all over the place. This was the first time that it was created as a standalone agency. And that law was crafted in that period when His Excellency was in the Federal Ministry of Justice. There was also the Arbitration and Conciliation Act, again crafted during that time. Then you will also remember the Laws of the Federation 1990. Yes, most of you who are lawyers will remember that. Again, crafted during that time. So this is somebody who has seen lawmaking from one point of view. When he finished his time with the ministry, with the Attorney General, he went back to the University of Lagos. He became a professor of law. Somewhere along the line, he became a senior advocate of Nigeria. In 1999, when we returned to civilian government, he became the first Attorney General of Lagos State post-military rule. And he was there for the 2 terms when the current president was the then governor. Again, during that time, there were a number of things he did which showed his mind in terms of how to reform society and organizations. That was one of the first states to move the revenue department out of the Ministry of Finance. In most states, revenue departments are part of the Ministry of Finance, but they created a standalone agency, the Lagos State Internal Revenue Service. And that's, as I said earlier, was what led to the increased efficiency collection, which Lagos State enjoyed and still enjoys up till now. Of course, those who pay tax may not be happy to hear about that efficiency. He was also involved in justice sector reform at the time. When he finished his time with Lagos State, he went back into practice. He was a partner in Simmons Cooper. Many of you may also not know that he was a director. He sat on the board of Citibank Nigeria. And he was on the board of Citibank Nigeria up until 2015, when he ran as vice president with General Muhammadu Buhari. He became the vice president. As vice president, one of his roles was to chair PEBEC, that is Presidential Enabling Business Environment Council, which still exists till today. Again, this was an entity designed to enable business do better. And before the end of his tenure, you may also recall that he was briefly the acting president of the Federal Republic of Nigeria. So as you can see, very few people, if any, have the antecedents which he has and which qualify him to speak to us today on this topic. Please join me in inviting His Excellency, Professor Opeyemi Osinbajo, SAN GCON. Sorry, we don't have a stand. You don't have to hold it.
Thank you very much. Please sit. The Attorney General and Commissioner for Justice, Lagos State, and representative of His Excellency the Governor, discussants, partners, and members of AELEX, senior advocates present, friends and colleagues, ladies and gentlemen. Let me begin with gratitude to the partners and members of AELEX for the very kind invitation to deliver this year's lecture, and also to commend this firm for the very many years of institution building and value creation. Your firm has proved a point that we can build strong institutions, private or public, where there's an ethos of professionalism, integrity, and an openness to respond to changing times. I must say that this is by far one of the best law firms anywhere in the world. Second only, of course, to Simmons Cooper partners. Thank you very much. I am to speak on the topic, the rule of law and economic development, the Nigerian experience. So let me first give a working definition of the rule of law and its context in this lecture. Looking at your faces, I am sure that you're not here to listen to a law professor give a full exegesis of the rule of law, the theories of the rule of law from Dicey to Joseph Raz, and those are even only the modern ones. We can go back to classical, medieval, and the Enlightenment. But I think that most of us sort of understand what the rule of law is, whether we're lawyers or not. And I think that a simple definition is that the rule of law really means that laws are clear, that they are fairly applied, and that they are equally enforced. So people, businesses, and governments all play by the same rules. No one, not even government, or its agencies, is above the law. Nobody is above the law. The rule of law should then give investors, businesses, and citizens the confidence that rules, not power, not influence, decide outcomes, whether those are institutional outcomes or outcomes in cases and all of that, in cases before the courts. To be credible, it's important that disputes must be resolved by independent courts and then bound by laid down precedents and legislation. And enforcement must be certain. But I think that the purist constitutional lawyers here will find that I have conflated two theoretical concepts in my definition, namely the rule of law and the administration of justice. So the rule of law, meaning that everyone must be subject to the law, that laws are clear, predictable, fairly applied. And then the administration of justice, meaning that the courts, the police, and the regulatory agencies actually enforce laws fairly, predictably, quickly, and without corruption. So my excuse for merging both is that except for just bare theoretical analysis, the rule of law and efficient administration of justice go hand in hand. In fact, sometimes they're used interchangeably. So the best laws are useless if the mode of enforcement is weak, if it's corrupt or inefficient, and if it simply does not deliver the results. My second preliminary point is about the broader legal and policy environment. So beyond the rule of law itself, we should consider how our entire body of laws, of institutions, from market rules to labor laws to socioeconomic rights, and the institutions that interpret, apply, and enforce them can create an environment for economic development, or an environment in which economic development thrives. But first, what do we then mean by economic development? Again, I will adopt a very simple description. Economic development means progress, the process by which a country improves the economic, political, and social well-being of its people. So in practical terms, this would typically involve sustained growth in incomes and jobs, expansion of infrastructure, better education and health, and an increase in opportunities generally. But I must say that too often we equate economic development with big business and investment. We talk about economic development only in terms of what satisfies big business or what pleases big business and investment. But true development is really about the real improvement in the quality of lives of ordinary people. And that's a far more complex and involved task than simply incentivizing investments. And it requires us to focus on people rather than just merely on programs and projects. Third point I'd like to make is that there is now hardly any credible argument against the proposition that the enforcement of the rule of law is important for economic growth. I don't think there's any real credible argument against that anymore. Study after study has clearly shown that when contracts are enforced, when businesses can trade and invest with confidence, when property rights are secure, people are willing to save, to build, and innovate. When corruption and favoritism are curbed, resources flow to the most productive users, not just to the most influential or the most powerful. When regulations are clear and transparent, consistently and agnostically enforced, it is easier to attract foreign direct investment and to stimulate domestic entrepreneurship. Also to encourage formalization of businesses, which in turn, as you know, expand the tax base and provide resources for financing the public goods that we all want and that the ordinary man wants. When disputes are fairly resolved, investors stay and they can expand instead of taking their money elsewhere. So in practice, strong rule of law enables growth by lowering uncertainty and transaction costs, while a weak rule of law would deter growth by raising risks, costs, discouraging long-term investment. Let me give a concrete example of my own experience. In the year 2000, while I served as Attorney General of Lagos State, and the current Attorney General was also there serving with me, the Governor, Bola Tinubu, now President Bola Tinubu, forwarded a report to me about a troubling trend. It showed that Lagos State's stock of low and middle-income rental housing was not growing. In other words, people were no longer building the number of people who used to build and who were expected to build low to middle-income housing were no longer building. They were preferring to invest in stocks and bonds rather than building houses for rent. The report explained why. It said many landlords simply lost confidence in the courts. The magistrate court process was painfully slow. Tenants would often pay for a couple of years, 2 years rent in advance, and then stop paying, betting that if the landlord sued, the case would drag on for years while the tenant stayed rent-free. So building rental housing just was no longer as attractive as it was. There were days in the past when people would say, my retirement is to build 4 flats and rely on the income from my 4 flats that I've built. But that was no longer the case. So the lesson was clear, and we decided that we had to take action. We reviewed thousands of pending landlord and tenant cases and confirmed that the rampant delays was just a problem. So we set up mediation centers as part of the Lagos State Justice Citizens' Rights Project. And these centers provided accessible mediation services, especially for small claims. We enlisted trained volunteer mediators, most of them lawyers in the Ministry of Justice, or we later on engaged other people, to help parties negotiate and to, to also help them to just resolve a lot of these landlord and tenant cases. As a matter of fact, as soon as the mediation centers were set up, landlord and tenant cases were practically all that they handled. So what would happen typically is that a landlord and tenant would meet with a mediator to reach a binding settlement agreement. And the results were quite remarkable. In 1 year, the mediation centers resolved over 8,000 landlord and tenant cases, whereas the magistrate court had completed only 2,000 within the same period. Today, the Lagos State government has, I think, about 18 or so mediation centers, if not more, and resolve over 20,000 cases each year, most of them landlord and tenant disputes. So by reducing delay and increasing certainty, the initiative restored some confidence in housing investment and unlocked thousands of rental homes. Of course, in a place like Lagos, the problem is enormous and continues to be enormous. But I think the moral of the story is that if you have delays in the courts, you can have other problems associated with development of the economy, of the state, of the nation. But the problem of delays in our court system is even deeper and much more pervasive. The Justice Research Institute very recently concluded a report on the question of the time it takes to resolve commercial cases in our courts. And that report was just completed in August of this year. And the findings are staggering. One, it says on average, a commercial case sits in the High Court for between 4 years and 2 months. If appealed, it will spend another 3 years and 4 months in the Court of Appeal. And if it goes on to the Supreme Court, it takes another 6 years and 6 months more to conclude. Now, that is when you get a date to be heard. Yeah. Altogether, a commercial dispute can take nearly 13 years from filing to final Supreme Court judgment. Now, these are just averages. Many cases take even longer. I'm sure that almost every practicing lawyer here knows of a case, even if you are not even a lawyer, will know of a case that has gone on for much longer than the averages that I've just spoken about. And that has happened all the way to the Supreme Court. I've had an appeal since 2012, and I don't even have a date yet for that appeal, although I will spare myself the trouble of even going to go and argue the case. I have my learned friend, Babalakin, SAN, who is here. Anyway, such delays are disastrous for business and investment, as you know. Delays in commercial trials is particularly disastrous. And a court of appeal had occasion to talk about delays in Nigerian courts in the case of IPCO and NNPC. That's a 2015 case. This was a challenge to the enforcement of a Nigerian seated arbitration tribunal award, which came before the English Court of Appeal. The court referred to the delays in the parallel proceedings, which were going on before a Nigerian court, as catastrophic, and I'm quoting the court. And the court said that it could take a further 30 years to resolve the case that was going on in Nigeria. Incidentally, the expert witness who testified on behalf of IPCO on delays in Nigerian courts was a former Chief Justice of Nigeria, who testified that it could take between 20 to 30 years to resolve a case in a Nigerian court. The court, as you know, is a taxpayer-funded public resource. The wasting or abuse of the finite time of the court without strict consequence will eventually discredit the system, and it is doing so incrementally, and affect the decisions of those who want to invest. So whether or not it's even worth their while, especially if a dispute emerges. So addressing delays must involve imposing sanctions by a more intentional regime of award of adverse and wasted costs. So I think that costs, especially for dilatory tactics coming from lawyers, costs will be very important. Adverse costs are paid, of course, as you know, to the successful party in a civil case, and wasted costs are directed against legal practitioners for poor professional standards in the conduct of a case. So severe costs should attend adjournments. And there is no greater waste of taxpayers' funds than for a scheduled case to have to be adjourned. I recall many years ago, while I was serving as advisor to the then Federal Attorney General, Nigeria had a case before the Royal Courts of Justice in England. And the counsel, the British counsel, was there already. It was a case involving NEPA at the time. And the officials who were supposed to come to court that morning, we had arrived the day before. The court was supposed to be on a particular day at 9 o'clock in the morning. Some of us had arrived the day before. The officials who were supposed to be there didn't show up until that morning. So they arrived first thing in the morning. I think it was at Gatwick Airport in those days. And they came to court, but we were sitting down there at 9 o'clock. Nobody, I mean, of course, all the other side was there waiting. Our own people hadn't showed up. So the court then decided at that point that it had to adjourn. This was about 15 minutes or so after. And said, well, our case would wait another date. But then the court fined the government. The fine was so huge that, in fact, we almost froze right where we were. I think it was something in the order of about £200,000 or so for just being late. But that way, you discourage people from just taking advantage, of the system and delaying cases. So it's only heavy costs, in my own opinion, that will discourage malfeasance. Then there are also other reforms that we can implement. We can have specialized commercial courts, and Lagos State government has now, established a commercial bench, which I am sure will certainly move cases on much faster. We must digitize actively our court processes. E-filing, digital dockets can speed up processes, and it's no longer rocket science. Everyone else, everywhere else, is doing all these things. So the increasingly corrupt processes for even getting dates, and you know that the process of getting dates now in many of our courts is becoming, quite difficult. So that process too is being corrupted. And that can easily be resolved by open and transparent digital processes that litigants and lawyers can even have on their phones, on their devices. And that's taking place in other countries, even other African countries, to check the process of their cases on data allocation, if they're on the queue for data allocation. So with various tools now, and there are so many tools, simultaneous recording of proceedings and production of transcripts is far easier, and the records are certainly much more accurate. And I'm sure that all of us know that with the developments in AI now, even judgments of our courts will probably be written by AI. So we're getting to a point where the honest truth is that very, very soon, ChatGPT will write a lot of the judgments very simply and give the court even options as to, well, if you want to decide this way, this is how to support it. If you want to decide that way, I mean, you know that that's already happening. I trust in another year, I won't be surprised if that's how cases will be coming to our courts, which again might at least lead to more, just conclusions, because you also, as counsel, can, do exactly the same thing, do exactly the same process, know what the likely outcomes are likely to be, and all that. So, but the IPCO case, this case that I had cited, the UK case, points to even a more serious problem. And this is the interference of courts in the arbitration process, in arbitration matters, where the courts interfere in arbitration. So arbitration is an alternative dispute resolution mechanism, which should ordinarily provide an escape from the delays that we have in our commercial court system. But often, the courts intervene on various grounds. For example, they may intervene on the basis of jurisdiction or arbitrability. There are all sorts of grounds. Now, that can lead to a situation where the arbitration award or even the entire process itself is annulled, or parts of the award is annulled. Now, this is a major source of interference. The Court of Appeal, I think in 2021, in Yatirim and Sahelian Energy, in 2021, set aside a foreign-seated ICC award. The seat of arbitration was in Geneva on the grounds that enforcement in Nigeria would be contrary to public policy, because the underlying contract, which was a cooperation framework agreement, was required under Nigerian law to be registered with NOTAP, with the National Office of Technology, of Acquisition of Technology and all of that. And it had not been so requested, it had not been so registered. So for non-registration in NOTAP, the court said that would be, if you enforce the award, it would be contrary to national policy and our interests. So it held that a Nigerian court has jurisdiction to set aside a foreign-seated arbitral award when Nigeria is the jurisdiction of enforcement. Now, that's a very dangerous proposition. But the Court of Appeal and another Court of Appeal, the first one was in Abuja. This other Court of Appeal in oil and industrial services and hempel paints declined jurisdiction to set aside a foreign-seated award. This particular award was in England, it was in London. It held that only the courts of the seat of arbitration have supervisory jurisdiction. That is the power to set aside. Now, that, of course, obviously makes more sense. But the Supreme Court is yet to clarify the position given the two conflicting approaches. The Arbitration and Mediation Act now categorically states that a court has no jurisdiction to set aside a foreign-seated arbitration. But I think the crucial point is that we must, as a matter of legal policy, discourage even more intentionally the interference of courts with arbitration. Because the moment a court gets into arbitration, it means that the entire ADR method is drawn into the slow judicial process, and it completely loses its advantage as a quick method of dispute resolution. So we mustn't even allow a situation where courts interfere, except in the most extreme and the most urgent cases. So, because the moment it does, all hope is lost. The whole arbitration comes back to the slow system. But enforcement of judgments, even after extensive litigation, presents yet another significant problem of its own. Enforcing judgment, even after you spend all the time in the courts, 13 years, 15 years, whatever, enforcement of judgments becomes a problem. And that is so, whether it's local or whether it's a local judgment or a foreign judgment that you want to enforce. There are far too many bureaucratic inefficiencies, procedural complexities, a lack of cooperation sometimes from law enforcement agents, inadequate mechanisms for asset tracing, and often judgment creditors simply abandon enforcement because of the high cost and the low success rate of some of the post-judgment procedures. Identifying, and seizing judgment assets is also a problem of its own. Now, government debts, of course, I'm sure that most practicing lawyers here know, government debts are even more notoriously difficult to enforce. I see Mr. Babalakin here nodding his head. He went all the way to the Supreme Court many times to enforce his own judgment debt. It's notoriously difficult to enforce. Section 84 of the Sheriff and Civil Processes Act, as you know, mandates that judgment creditors must obtain the consent of the Attorney General of the Federation or the state, as the case may be, before initiating garnishee proceedings to enforce monetary judgments against government or any of its agencies. Of course, that consent is unlikely to ever come. But I'm sure some of us are familiar with the dissenting judgment of Justice Ogunwumiju when she declared that Section 84 is unconstitutional. She argued that it violates Nigeria's constitutional provisions on separation of powers and judicial authority and all of that. The truth, anyway, is that the Supreme Court has affirmed time again and again that the consent of the Attorney General must be sought, and it has not modified that position in any real way. So I think Justice Ogunwumiju's dissenting judgment was helpful because at least it pointed in the likelihood of a different direction one day. While I personally agree with the principle that enforcement of judgments against governments should not be subject to government veto exercised by the Attorney General, yet I'm sometimes in two minds about the way forward. Because I have witnessed several situations of collusion between private individuals who are purported judgment debtors and unscrupulous government officials who connive to enforce bogus debts. And very often this occurs by government not opposing or contesting the purported debts and cooperating actively to enforce the same debts. And this scandalous attempts to do this, for instance, in the Paris Club refund cases, and there's so many of those cases now, is one such example where this sort of thing took place. I had the unpleasant task of reviewing some of the Paris Club refund cases and concluded that it was a fraud. Many of them were just frauds on the system, and had the active collusion of public officials who would benefit from these. So, as I said, one is sometimes in two minds about whether you shouldn't have a situation where there's a review of it, but I mean, it certainly isn't, it certainly in my view is unconstitutional to have a situation where the judgment of a court is subject to a further process of approval by the Attorney General of the Federation or Attorney General of the state. One of the fallouts of the uncertainties in the ability of the civil justice system to deliver swift and certain redress in many civil cases, even in debt recovery matters, is the criminalization of civil matters. So a breach of contract or a debt owed may very quickly become obtaining by false pretenses or fraud. So the objective of the complainant is to leverage the threat of detention in police custody or even criminal process to have the police and other law enforcement agents chase after a debt that is owed, or even simply redress in a breach of contract situation. So the thinning line, and I think the line between civil and criminal action, is becoming thinner and thinner. And this is certainly a turnoff for local or foreign investors if you realize that because of a breach of contract or debt that is owed, you can suddenly become a criminal and go through a criminal process, detained for a while and possibly even locked up. We simply must draw clear lines, and I believe that both the executive and the judiciary and the private sector have roles to play here. Let me now turn very quickly to the criminal justice system, which I think is an often overlooked barometer of governance. A robust criminal justice system is, in my view, the foundation of law and order, and thus commerce and democracy. So when criminal justice breaks down, all these pillars of society are at risk. And in Nigeria, sometimes we see symptoms of a breakdown of significant aspects of the criminal justice process. So for example, out of the 200 million people who are in this country, only about 26,000 are convicted and serving sentences in prison. 26,000 of, 200 million of us. While about 81,000 others are awaiting trial, one way or the other. Now, by contrast, the United States, which has about 300 million people, has roughly 2 million people in incarceration, in prison. The United Kingdom, which has about 67 million people, has about 80,000 people who have been convicted and who are in jail. So 4 times more than we have who have been convicted and who are in jail. So of course, I mean, it means that we're either remarkably well-behaved people or there's something wrong. There's something wrong with the system. So many crimes, as you know, go unpunished or take years to resolve. For ordinary citizens, it creates an environment of impunity. Small business owners, for instance, I was speaking to a group of small business owners in a town hall setting where they had, talking about the various issues and complaints that they had. And one of the complaints that kept repeating itself was that many could not open new branches or were not willing to open new branches of their business where they couldn't personally supervise operations because it simply wasn't worth their while. Why? Because of the rampancy of theft by staff or shoplifters who know that even if they are caught, they're unlikely to be punished. So the cost of doing business and living, securely rises for everyone, not just for investors, but for everyone. So commerce is disrupted, investment declines, and all that. The consequence for criminal conduct is important to create an environment that encourages businesses to take greater risks, to expand, and to settle into a better routine where you are almost certain that the only thing you need to worry about is how you're growing your inventory and how you're attracting customers. Another fundamental element of the rule of law is consistency and predictability in judicial decisions. Businesses need to plan for the future. And for that, they need to know the rules. They simply need to know what are the rules. And sometimes we find that even lawyers cannot say with confidence what the law on particular points is. They cannot say to you, I am sure that this is the position of the law. The jurisdiction of the Federal High Court, for example, and many of us are familiar with this, Section 251 of the Constitution, gives the Federal High Court exclusive jurisdiction over cases involving the federal government and its agencies. Now that sounds pretty straightforward. But the Supreme Court, in its several decisions, has sometimes been inconsistent and contradictory. One line of cases, beginning with the famous NEPA and Adegbero in 2002, going to other cases, along Toba, Uju, there's Amosu, then there's, so many of these cases, essentially say that the mere presence of the federal agency as a party gives the Federal High Court exclusive jurisdiction, regardless of the subject matter. Then there's another line of cases, starting with Onwara, in 2005, and recently reaffirmed in Attorney General of Lagos State and National Sports Lottery, which holds that two conditions must be met. First, a federal party must be involved, a federal government or an agency. Second, the subject matter must fall within the Federal High Court's constitutional jurisdiction, as stated in 251. But then there are more head-spinning controversies as to when the Federal High Court has jurisdiction in contracts. The distinction between simple and technical contracts, that can get very blurry. And if you look at some of the cases, you're not even sure what's going on. I think it was in April this year, April 2025, that the Court of Appeal in a case called CBN and Adani Mega Systems upheld the Federal High Court's jurisdiction in what would appear to be a simple contract because the contract implemented pre-shipment inspection statutes, which themselves, according to the court, channel proceedings to the Federal High Court. Now, this is a narrow situation. In other words, the court was saying that when the contract is in furtherance of a statute and that statute confers Federal High Court with jurisdiction, then it's a Federal High Court. It's a matter within the jurisdiction of the Federal High Court. But the Supreme Court is yet to endorse this new categorization. But the point anyway is that there is a real problem where you have these, almost these problems are just morphed one after the other. I think that after more than 20 years of these conflicting approaches, lawyers still cannot predict the outcome of this question with confidence. And this kind of uncertainty is, in my view, the antithesis of a mature rule of law environment. I think the Supreme Court can, in one case, simply face all the controversies head on and lay down the applicable principles in every situation. And if it does, and it is possible, can take all of these cases, review all of these cases, as it has done, and it has done so commendably in some of the cases, even if you don't agree with the outcome, but at least you know that the effort has been made to outline all these problems in one case. Just take one case, outline all the problems, and then tell us what the position is. So once they're able to do so, of course, it makes it much easier for everyone. Again, in the area of regulation and regulatory enforcement, there is a nagging problem of inconsistent regulation and weak enforcement. In key sectors, different levels of government have conflicting rules and apply them unevenly. So this creates uncertainty, it encourages corruption. For example, in the oil sector, environmental protection in the oil sector, for instance, you have overlapping federal and state environmental rules. Slow enforcement, heavy reliance on companies' self-reporting processes have allowed many of the major oil firms to delay cleanup and avoid penalties. Communities, of course, are left exposed and tensions rise. To fix this, we need clear and unified rules. Digital filing systems, for example, a single point of regulatory contact, and strong independent regulators with third-party audits to rebuild trust and ensure accountability. And what happens in the environmental sector and in the oil sector, for instance, is it repeats itself in several different ways. How about land and property insecurity? I doubt whether there's anyone who hasn't had to deal with problems associated with the uncertainty of title and the rampant use of self-help and even violence to enforce property rights. This, of course, reduces access to credit, it discourages long-term investment. Land use reform in Lagos State has been a long-running engagement, and understandably so. This is Africa's fifth largest economy. Everything is about title to land. So we need to do all the hard work of advancing digitization of land records and firmly establish a complete statewide digital land registry with searchable titles and parcel maps. This is now even more doable with digital technology and AI. We must also provide a lease pendants registry, which is linked to the digital land system. I'm aware that the Lagos State, the Attorney General's office, is working on a lease pendants registry currently, and that's so important. We need to have a registry where you can go to and find out whether the land you are about to buy is in dispute in a court of law. It should be a straightforward thing, so that you can then decide whether to take the risk or not to take the risk. But there should be a registry somewhere that is able to tell us. So I'm so happy that the Lagos State government is already working on that, the Attorney General's office. Also, perhaps it's time to simplify and unify title issuance processes. Create a single window that, the issuance workflow that harmonizes both federal and state and local requirements and accepts certified electronic documents. And this is the perfect time. I must say that we're in the very perfect time. The president used to be governor of Lagos State. Lagos State has most of the disputes. To align federal and state, the various federal and state controversies and problems, this is the time to do so, including local, so that we can actually have a registry that is able to, a one-stop regulatory place here, perhaps in Lagos or in Abuja, where we can resolve many of these disputes. And it's necessary to do so because Lagos stands out. This is where most of the commerce in this country and most of the business in this country takes place. There's also an interesting model that I've seen work in Rwanda. And it's the requirement that they have where you have large land transactions. So they require independent cadastral surveys and third-party verification for major land transfers. And where you have mortgage-backed lending, where it is substantial, that is always required. So the way it works is that the government will appoint accredited private surveyors, including NGO monitors, and then there's community validation sessions to produce verified parcel maps that are cross-checked against all the administrative records, and then it is advertised, it's publicly posted. This process would obviously deter corrupt conveyancing, protect buyers from disputed land, and to enable mortgage finance by giving lenders a bit more confidence, and then generates very high quality spatial data for planning and revenue collection. Then there's the issue also of consistency in the application of government policy and rules. Consistency in application of rules, government policy, and all that. Study after study has shown that where you have policy reversals, it generally hampers investment, both local and FDI. Succeeding administrations, generally speaking, tend to abandon or reverse the policies of their predecessors. Banning and unbanning of agricultural products, for example, sudden changes in licensing fees and spectrum allocation rules for those in the communication space. Telecom operators and tech startups have faced regulatory uncertainty, affecting, of course, their expansion plans. But what can be done? What can we do about that? A few suggestions. I think there should be institutional reforms to ensure policy continuity. And we simply must be intentional about this. How can we reform our institutions so to ensure that as much as possible there is policy continuity? There should be stakeholder consultations before major policy shifts. And we can do this by law. We can also create a national investment charter, and we can get cross-party support for that sort of thing, making it more difficult for government to arbitrarily abandon what its predecessors have done. Also, we can be creative about legal safeguards and devices to protect long-term investments from abrupt reversals. Nigeria has had some experience with local safeguards. Some of us will remember the Oso condensate project in 1990 to back that major project at the time. So that special law empowered the NNPC to borrow in any currency, to guarantee loans for the Oso field development, and it even stated that its provisions would override any conflicting laws. These assurances, which were provided in that law, and some would refer to it as an OSO specific law, these assurances eliminated bureaucratic hurdles and gave Mobile and its partners the confidence to proceed, the confidence to invest, because they were, of course, afraid that given the sheer size of the investment, they couldn't take a policy reversal. So they insisted on an also specific legislation, which in the schedule included the agreements that they had reached with government. And this, the success of that particular project and the law has given confidence to government and its partners to use similar project-specific frameworks. And some have been used, of course, as you know, with Shell, with Chevron, with Total, and others. Also, I think, as I had said in my earlier comments, the duty of the state to provide for the welfare and security of its citizens is a fundamental imperative of state power. Whether or not, whether we accept the position or not, it is clear that the business of government, the fundamental business of government, is the security and welfare of the people. Our Constitution provides socioeconomic rights on education, on healthcare, on housing, employment, social welfare, etc. Although, of course, these are not justiciable rights, but those provisions remind us that development must reach the poor and the marginalized. And these rights, as we know, are not necessarily directly enforceable by our courts, but they should shape our priorities, especially in a country where the majority of people still live in conditions of poverty or informality. We cannot rely on a trickle-down, approach. where we expect that if industry prospers, if commerce prospers, then people will prosper. The bottom of the pyramid is too large for us to ignore the fact that we need people-centered governance policies that place the needs of the ordinary citizens, especially the young people, at the core. Africa, and of course Nigeria, has the youngest population in the world. Nearly 70% of us are under 25. And the failure to address these needs, of course, will threaten security, which of course means it will threaten economic development. By putting ordinary people first, by expanding opportunity at the bottom of the pyramid, we can make our society more stable and growth more sustainable. This is not only, in my view, a moral path, but I think it's the pragmatic path if we expect sustained economic development. So let me conclude by saying that I think it is fairly clear that the problems are generally not problems of lack of policy or laws. There are more problems of weak institutions, weak execution of policies and rules, human type of problems. It is evident that we must reduce human discretion in the operations of our regulatory agencies. There's a need also to rethink our approach to reform. There must be a meeting of the minds between the executive, the legislature, and the judiciary. And I speak about a practical sit-down meeting. Strangely, that doesn't necessarily happen often. But there's a need for there to be a sit-down, a meeting. And also, eventually with the private sector, to determine what needs to be done. Because every problem is human. Each of these sectors must see the failings and how one failing somewhere affects the others. So they must then decide to collaborate intentionally in order to deliver economic development. These are human problems, and they're not insurmountable. All I think we need is the will to do so. And trust me, it is us who are going to have to solve these problems, not spirits from somewhere. Thank you all very much.
Wow. I think we all need a minute just to breathe. Yeah. That's what you call a masterful delivery. He held us spellbound for, he was supposed to take 40 minutes, but yes, I think we'll all indulge him. So please, another round of applause for His Excellency. I hope, thank you. I hope you are all taking notes. I did. Let me just check my notes. I liked the innovation from other jurisdictions where hefty costs are awarded against litigants that unduly bog down the speed of administration. I wonder, those of us that are lawyers, how would tell our clients that we've been slammed with £200,000 cost? I think for some of us, we will just sack ourselves from the court. I also liked ChatGPT judgments. Yes, AI. Yes, that's the future. AI. A lot of us are getting with the program. The intersection between the rule of law and technology. That was a very useful insight. I liked the pithy summation that development must reach the poor and the disadvantaged, because the bottom of the pyramid is actually the largest. So let me conclude with the one I think we should all take away from here. The same rules should apply regardless of whether you're dealing with governments, institutions, or persons. For those of us that are from the aviation industry, we know the ruckus that happened recently when there was selective application of the law to some travelers. I'm sure most of us remember. So thank you very much for that very, very, very impactful presentation. I would like to invite the partners of AELEX for a very brief photo session as we prepare for the panel discussion. So a photo session with the keynote speaker and the partners of AELEX. So please. Okay. I've just been informed that there's a bit of a change in the program of events. So because of time, we'll move straight into the panel discussion. So just to set the tone for the discussion before I invite the discussants, we are talking about the rule of law today. The rule of law has really evolved ever since AVIC articulated the 3 core principles of the rule of law. These are, the first one is the absolute supremacy or predominance of the law as opposed to the influence of arbitrary power. So that came through in His Excellency's speech. The second foundational principle is equality of all before the law. And the third one is an independent judiciary that determines people's rights and obligations under the law. So the marriage of rule of law and administration of justice that His Excellency did really has firm footing even in the origin of the concept itself. Our most distinguished panel is eminently qualified to do justice to this topic, and I can't wait to listen to their views on what is decidedly a very critical topic at this time in our nation's history. So please join me in welcoming the distinguished panel.
Your Excellency, Honorable Attorney General, distinguished ladies and gentlemen, I hope I can be heard. Before we will welcome the panel up to the stage, allow me to introduce them to you, if you do not know them, and reintroduce them to you who are already familiar with them. Our first discussant is Dr. Wale Babalakin, SAN. Dr. Babalakin is the senior partner of Babalakin & Co., a leading full-service law firm in Nigeria. He was conferred with the distinguished rank of Senior Advocate of Nigeria in 2002 and has served as a member of the Body of Benches, the legal body of practitioners of the highest distinction in Nigeria. Dr. Babalakin served as a member of the National Political Reforms Conference in 2005, where he was chairman of the Constitutional Drafting Subcommittee. He was also vice chairman of the Committee on the Review of the Evidence Act, Cap 112, Laws of the Federation of Nigeria 1990 in 2005. In 2007, he was appointed as the Honorary Special Advisor on Legal Matters and Counsel to the former President of the Federal Republic of Nigeria, late Alhaji Musa Yaradua. He was conferred with the National Honor of Officer of the Federal Republic of Nigeria. I beg your pardon. National Honor of the Officer of the Federal Republic, OFR, in February 2008. Dr. Babalakin is the chairman of the Courtney Limited, the concessionaire of Murtala Muhammed Airport Terminal 2, MMA2. MMA2 is the first design, build, operate, transfer project of such magnitude in Nigeria. It remains the only privately funded airport terminal in Nigeria. It is also the first of such public-private partnership projects for an airport terminal in West Africa. Please make welcome Dr. Wale Babalakin, SAN, to the stage.
Our next discussant is Dr. Chinyere Almona. The first one, sir. Our next discussant is Dr. Chinyere Almona, FCA. Dr. Chinyere Almona has over leadership and management experience. She's an expert in corporate governance, sustainability, gender diversity, and her experience working across private, non-governmental, and international development sectors. Dr. Almona was recently recognized as one of the 50 most influential women leaders in governance, risk, and compliance. She was on the 50 Women in Management Africa WIMA 2022 award list and has also made the list of 15 inspiring Nigerian women in 2022. She was listed among the 40 top women across Africa on the 2020 African Women in Banking and Finance Awards list in 2020. Dr. Almona is currently serving as the Director General and the Chief Executive Officer at the Lagos Chamber of Commerce and Industry, the foremost chamber of commerce in West Africa, established in 1888. Previously, she led the Africa Corporate Governance Program of the International Finance Corporation, which provided a wide range of corporate governance reforms across 13 African countries. Before joining the IFC, Dr. Almona was a director at PricewaterhouseCoopers, where she established the governance, risk, and compliance practice. Ladies and gentlemen, may we welcome Dr. Almona to the stage. A brief round of applause.
Our third discussant, Mr. Bismarck Rewane, who unfortunately, or not unfortunately, but regrettably, isn't here physically with us, but has painstakingly decided to join this event virtually. Mr. Bismarck Rewane worked with the First National Bank of Chicago, which later became the International Merchant Bank, Nigeria Limited, as a general manager and treasurer. He has over 40 years' experience in the financial services industry. Mr. Rewane has served on the boards of FCMB Limited, FCMB Bank UK Limited, Lion Bank of Nigeria, Intercity Bank Limited, Top Feeds Nigeria Limited, Delta Packaging Nigeria Limited, CPEC Nigeria Limited, Nigerian Economic Summit Group, Modern's Marine Limited, Virgin Nigeria Airways Limited, Nigeria LNG Prize Award Foundation, UBA Custodian Limited, UNIC Insurance PLC, Navgas, a vital subsidiary, and Guinness Nigeria PLC. He is currently the Managing Director of the Financial Derivatives Company Limited. Mr. Rewane holds a bachelor's degree from the University of Ibadan and is an associate of the Institute of Bankers, England and Wales. Please join me as we make welcome Mr. Bismarck Rewane, who is here with us virtually. Thank you, sir.
Thank you for having me.
Okay, so that completes our lineup of discussants. We are going to invite a distinguished gentleman who has the wherewithal to handle such a distinguished panel. So join me in inviting our moderator. Our moderator for today is Opeyemi Agbaje. Thank you. Welcome. So before I hand over the mic to Osinbajo Agbaje, I will just introduce him briefly. Osinbajo Agbaje is the chairman of the National Pension Commission, PENCOM. He is also the chairman and CEO of RTC Advisory Services Limited. He founded RTC Advisory Services Limited, a leading strategy, policy, and economy and business advisory firm in 2004 after a successful career in banking and financial services. He is also chairman of Stairways Communications and Advocacy Limited and the Opeyemi Agbaje Institute Limited by guarantee. Opeyemi Agbaje joined the faculty of the Lagos Business School as senior fellow in strategy and business environment, and later as head of Department of Strategy and Entrepreneurship. He was a director of Chemical and Allied Products PLC from 2009 to 2019, trustee of the Lagos State Security Trust Fund from 2011 to 2019, and chairman of the Convention on Business Integrity. He worked in government as executive secretary, CEO of the Ogun State Security Trust Fund from 2019 to 2021, and voluntarily resigned after a very successful 2-year tenure. Osinbajo Agbaje holds the Merit Award of the Igbobi College Old Boys Association for Professional Excellence and the Gathering of Africa's Best, the GAB Award for Excellence in Consultancy Services, presented in London, United Kingdom in 2013. He is an honorary senior fellow of the Chartered Institute of Bankers Nigeria, CIBN, and member of the Nigerian Bar Association, the International Bar Association, and Institute of Directors Nigeria. He is a member of the Global Strategic Management Society, USA, and served for 2 years as representative for Africa of its Strategy Practice Interest Group. So please join me once again to give a resounding round of applause as I hand over the proceedings to our moderator.
Thank you very much. Let me issue a public notice, which I told her. My name is Mr. Opeyemi Agbaje. Although they gave me those titles, but I don't use them in official, especially in official. And if I must use a title they gave me, I would use Sir, because that was given by the Methodist Church of Nigeria. Okay, but that's besides the point. So I guess since we're in the gathering of lawyers, I have a very distinguished panel: Bismarck, Dr. Babalakin, SAN, and Mrs. Almona from the Lagos Chamber of Commerce and Industry. But in this context, I would suggest it's wise to start with the lawyer so I don't get into trouble. So Dr. Babalakin, Prof gave us a very simple definition of the rule of law. Perhaps we should start with your conception of the rule of law and to situate it within the context of business. How, apart from being a lawyer, we also know you to be one of Nigeria's major entrepreneurs, especially in the aviation sector. So perhaps, what's your conception of the rule of law, and how do you situate the rule of law within the context of economic development, business, and all of that?
Thank you very much. I'm happy to see Professor Yemi Osinbajo here, and I always admire his presentations. I thought after years in power, you will have lost some of the gifts of speaking very well, but I think it's now even further enhanced. The rule of law is a very simple concept. It simply means let us do things according to the rules as established, and let there be consequences for bad behavior. And agreements, once reached, must be honored. And the rule of law, if properly articulated, will create a great environment. And the failure to do it is what we have today in the country. So I don't think the issue for us is the definition of the rule of law. I think the issue for us is understanding the concept of law. The concept of law means that we have a framework that enables us ensure that things we do are within legal parameters. Where we have failed and failed woefully is that we don't have today a concept of law. A lot of people believe that qualifying as a lawyer is what makes you a lawyer, but it's more than that. If you read law without understanding the philosophy of law, without understanding the jurisprudence of law, then you are just a technician. You are not a technologist. If people studied law properly, based on how law evolved, fundamental human rights, rights of everybody, a lot of laws that are passed in Nigeria will never have been submitted to the legislature because they don't even have the content of fairness and the content of justice. The executive arm is always seeking to acquire more powers that do not require any surveillance. And we've seen so many laws passed today that don't have that will make a trained lawyer of the older generation simply faint. Simply faint. I don't know where the derailment started, but we have derailed substantially. I don't know how much time I have. Look, you cannot have a legal system where the judges are not the most outstanding lawyers with the highest integrity. You cannot, because the quality of law you get depends on the capacity of the judge. No matter how brilliant you are as a lawyer, if the judge cannot follow your arguments, you are wasting your time. I'm not a mathematician, but I'm told that once you have a negative denominator, no much how high the positive integer is, you will be negative. You can't have a legal system where the movement from the High Court to the Court of Appeal is not based on outstanding contribution, but is based on geographical spread and other considerations. You can't have a situation where the Supreme Court is not occupied by the most gifted lawyers in the system. You can't. If you don't do that, you wasted your time. I think it was the 10th anniversary of Kayode Ishofola's death that I delivered a lecture. That lecture made me go into the membership of U.S. Supreme Court and the membership of the then House of Lords in England. Almost all the CVs of judges were similar. They had graduated as the best student, prize winner in their universities. They had moved on to either academia or to practice. They had distinguished themselves. Every CV was consistent. So you find that in such places, they've made a conscious effort to put their best minds in the judiciary. What is sad about Nigeria is that that was what we had in the 50s, in the 60s, and early 70s. That was what we had. It was a deliberate decision of the government, led by the government of Western states, to create an outstanding judiciary. During the constitutional reform, I mentioned to somebody very important. I said, look, do you know that the salary of a high court judge in Western Nigeria was £3,400? the salary of the governor of Central Bank was £2,700. The salary of the Awujale was £1,500. A high court judge in Western Nigeria was beyond want. Beyond want. And they were hand chosen. I was in the company of Justice Ogudare once, and he asked me, what is the pecking order now in the profession? I said, I don't know. He said, what do you mean that you don't know? He said, in their times, they all knew who was likely to be appointed. That there was no strange appointments. They all knew that, it's Tio Emua's turn. Everybody just pull back. But today,
I think
yes,
Dr. Babalakin is making very serious points that go even beyond the topic of today, but go to the basis or the foundations, and I do not disagree with him, to the foundations of the legal profession and the judiciary, and like Prof said, the administration of justice in Nigeria. So it gives us a lot more to think about than just the intersection of law and economic development. He is actually questioning the very foundations of the application of law and justice in the country. But I'll give him an opportunity in the closing remarks to go back to that point, if you don't mind, sir.
Am I still on?
No.
Okay.
Thank you. I think AELEX made the mistake. You needed 2 keynote speakers for today. But so, Dr. Almona, you represent business, and it will be very. I'll come to my brother Bismarck, who speaks to the economy. But let's hear the business perspective from your members and from the business community about the relationship between the rule of law and economic development in Nigeria, and what institutional challenges you see that militate against these things that both the Prof, His Excellency, and Dr. Babalakin have spoken about. How does the absence of the rule of law or the imperfections around the rule of law, and also in its regulatory dimension, how do they affect businesses in Nigeria?
Thank you very much, and good afternoon, everyone. Thanks to AELEX for being consistent these 19 years to put this together. Thanks, Your Excellency, for that excellent delivery. I felt like I was in a classroom. All I need now is a certificate for this, maybe an exam. And greetings to Mr. Governor, represented by the Attorney General of Lagos State. For me, from the business perspective, is to think about some of the challenges that His Excellency x-rayed in his presentation. When I think of regulation, and today I got a very simple definition of rule of law, but I think rule of law, in my mind, is that intangible infrastructure that should enable business, that should enable economic development. However, there are then several challenges or weaknesses that we experience in Nigeria that I guess it is kind of difficult for the rule of law to actually align appropriately to economic development. So I think of regulatory capture or politicized agencies. So a lot of the regulatory agencies that are supposed to set rules, set laws, to support business development or to create an environment, an enabling environment for businesses, they've been so politicized that they are almost like an appendage of whatever the political power say, and how they're not able to actually deliver on their mandate. But then there are also these overlaps that His Excellency mentioned. There are overlaps, and sometimes you have conflicting policies or conflicting position on a particular thing. So sometimes the customs expect you to do one thing, but some other agencies expect you to do something else. So often businesses are kind of confused, who should we follow? But then you also find that the agencies are largely underfunded, understaffed, and overburdened. So at the end of the day, you have agencies who should facilitate something, but they're busy trying to make money, to fund staff, to fund computer, to fund this and that and that. So they're then putting pressure on the private sector in order to kind of fulfill this other mandate that's been given to them to raise funding. But then you also then have court delays and uneven enforcement, which means that the value of contractual rights have been minimized. So that, what's the point getting into a contract if you can't enforce it? So every business person is thinking, what is the outcome? Can I enforce the contract? Can I repatriate my money? Can I do business in a fair manner? But then if we can't go to court, we can't trust the court system, and you don't have robust alternative mechanisms, then it then becomes very difficult for you to do business in a way that will promote the economic development that we'll talk about. But you also then have issues around corruption and arbitrary judgments or decisions about things. So it then depends, it's not necessarily about what you're doing or whether it has merit or not. It depends on who you know. So at the chamber, a lot of times, I have my members calling out, DG, they have locked our shop. What did you do? They came with police, came with army, came with everybody. What crime did you commit? Either you haven't paid one levy, television levy, umbrella levy. It's almost incredible. And then they kind of slam you short and you really can't do business. Having said that, that then increases the cost of doing business itself. Because the period where you are not able to actually do business, you have to kind of build that cost into something. So we talk about inflation and the fact that the cost of goods and services have gone sky high. It's sometimes because of the regulatory pressures that businesses have to face, or the cost of the pressures that businesses have to face that make it kind of difficult for them to progress. So these are the things that affect businesses, and we're hoping that in conversations like this, we can actually move the needle through advocacy.
Fantastic. Thank you very much. That's a convenient point to thank Dr. Almona for her comments. Let me turn to Bismarck. I know that, Bismarck, I hope you can hear me. Okay, so I know that as an economist, Bismarck may think of this subject or this topic in terms of uncertainty, investor confidence, predictability, all of those concepts, cost of doing business, transaction cost, as His Excellency put it. How do you think the rule of law or the limitations regarding the rule of law or the imperfections thereabout, how do they affect business, especially in the context of Nigeria's reforms and Nigeria's economic conditions? Bismarck.
Yeah. Opeyemi, thank you for being here. Once again, for being appointment as the head of the pension. When I thought that you were head of the pension committee, I posted my case. I said, now, because savings is a critical part of the investment function, and that if the pension commission is in a safe pair of hands, then it's up of our president. But having said that, I say the following. I'm going to look at this, the question of rule of law and economic development from three different perspectives. First is that what does development mean, right? And economic development. And here in Nigeria, we confuse most times development with growth. Development also we confuse at times with infrastructure. Therefore, if there's power supply, then there's development, but that doesn't mean anything. So development has both its physical attributes, its institutional attributes, as well as its moral compass as a country. So, and in doing this, when I was thinking about this topic, and unfortunately I'm not here because present today because I'm bereaved and I'm just going through a funeral for my cousin, which we just finished a few minutes ago. I looked at different things and I said, let us first look at which countries are the fastest growing countries in the world in the last year. And those countries happen to be Guyana, Macau, Palau, Niger, and Senegal. Of these countries, the fastest growing was Guyana with 33.9%. Niger was the fourth, which was 10.4%. Niger is our neighbor here where there's had some military problems. And Senegal, 8.3%. And the question is that, are you better off being living in a fast-growing economy like any of these countries, or living in a developed economy? And I'll give you an example of a developed economy, Japan. Japan is highly developed, in fact, overdeveloped, but having very slow growth, at times negative growth. And if human beings are looking for happiness or welfare, one would say that you jackpot to places where you think your welfare and your happiness is guaranteed. And I have not seen anybody jackpotting from Nigeria to Niger yet. Yet there are a lot of people who are jackpotting across the ocean to Europe because those are developed economies, even though they may not be fast growing. I think that's very important to know that. So, why are countries developed? And how do they stay developed? And that if development is guaranteed and you have developed, then growth is built on that as a platform. So first of all, let's clarify that growth and development are two different things. You can grow rapidly and then what we call an abortive stage of growth, and then you now come back and actually abortive stage of growth. But when I was doing this, I looked at the Nobel Prize in Economics was awarded only about 2 days ago, 48 hours ago. And this time, it was given to Joe Moki, who is from Northwestern University, and he's an economic historian. And part of it was given to him. Philip Aghion from INSEAD was given the other part, and Peter Howitt from London School of Economics. Typically, if you look at the Nobel Prize in Economics, the bulk of them go to the University of Chicago, then MIT, Harvard, in a few cases, Stanford, but the University of Chicago, we have Milton Friedman and the man of rational expectations studied there. Now, what was the case this time on sustained growth? Now, Joel Moki talked about innovation-driven economic growth, and he did his work in 1992. Therefore, he was worried and he was thinking about innovation leading to sustained growth and maintenance of that growth. Also, the other guys, Peter Howitt and Philip Aghion was in INSEAD and Sciences Po in Paris, and Peter Howitt, as I told you, was in London School of Economics, talked about sustained growth through creative destruction. Please note, sustained growth through creative destruction. And it took, for example, it took the use of the telephone, which created creative destruction, but also led to phenomenal growth. And in the 5 revolutions that we've had, from the agrarian to the industrial to the digital to the AI growth, every time there's been these revolutions, there's been astronomical increase in output, right? And also astronomical increase in the difference between the poor and the rich. That is something that, so when we talk about development sets the basis for growth. The growth allows you to actually increase output. And then also, you as a government, as a people, have to look at how to narrow the differences between the rich and the poor so that you don't become stupendously rich while other people are poor. I think that's the most important thing. So, as Professor Osinbajo had mentioned earlier on, and I listened carefully to the pillars on which the rule of law is established. If you do not have rule of law, then you are guaranteed anarchy. If justice delayed is justice denied, injustice anywhere is equal to injustice anywhere is equal to injustice everywhere. And therefore, investors, Nigeria has decided to adopt what they call a mixed model, both investment-driven and consumer-driven and government-driven economic growth strategy. As long as investors, both domestic and international, find it difficult to believe in your rule of law, they will not invest. And if you are starved of investment, you are starved of growth. And if you are starved of growth, you are guaranteeing poverty and inequality, and so many other things that we don't want to argue about at this time. So my point is that you will not get development, both institutional, both physical, and both moral, if you do not have a rule of law where there's justice. Because the opposite of rule of law is rule of the jungle. And rule of the jungle is guaranteed anarchy. So I'm not going to go and invest. I saw Niger having 10.4 there. I'm not sure what's going to happen in Niger because it's under military rule. At times, it's better to have military rule than to have pseudo-democracy. But the truth is that investors, both domestic, international, and others, are looking to ensure that there's rule of law and not rule of the jungle. Thank you very much.
Thank you, Bismarck. And Bismarck reinforced His Excellency's point about social equity. It's a point I know he has always been passionate about. I had the privilege of having a lot of conversations on social investment, how we can remedy poverty and use economic policy to help the poor. Let me come back to Dr. Babalakin, and I'm going to allow him to continue his expose on the state of the judiciary, the legal profession, and all of that, and how it affects administration of justice in Nigeria, but then what reforms he would suggest. What changes? What would you like to see change, sir?
Thank you very much. The first thing is that we must endeavor to have a knowledge-driven nation, a knowledge-driven economy. And this requires substantial investment. Deliberately or inadvertently, we have killed our primary and secondary schools. You only have a few private ones that are providing the sort of quality education that is required. If the mass of your people are not getting good education, where are you going to get manpower from? Today, we pretend to be a wealthy nation, but the statistics show that we are a very poor nation. If you look at the entire budget of Nigeria and you invest heavily in education and health, then you will know that we have very little for frivolity. But when you abandon all this and you keep thinking that big projects are the symbol of growth, you are preparing your next generation for doom because there is no capacity. we get to this stage and start talking as lawyers. What is the quality of law teaching today? It's a far cry from what we had in universities. I recently sat in an interview for lawyers. 440 lawyers applied to our firm. They shortlisted, and finally, the last 24. That was the first time I was sitting in an interview for 17 years. And I only posed one question. Please, discuss one case that thrilled you, irritated you, or you found fascinating in your 4 to 5 year of legal education. Of the 24, only 4 could discuss one case. And all of them had 2 1s and first classes. Of the 4, only 3 schooled abroad. So you need to start asking yourselves whether we are preparing ourselves for the next level. Economic development will not happen without manpower. Most of the people taking wrong decisions are not taking it. Well, some are malicious, but a lot of it is driven by ignorance. When we commissioned MMA2, and I was to speak, and I said, the biggest challenge we had in putting the PPP together was ignorance. The person to supervise us had not done one before. The engineer attached to us had not seen one before. All of us were grouping. We had to go and bring South African architects, South African engineers to guide our own people because they had not done one before. So when President Obasanjo picked up the microphone, he said, no. Wale claims that the only problem is ignorance. And there are 2 other ones that Wale did not mention. He said, 1, deliberate refusal to understand, and malice. The thinking of the average person is that you are stealing government assets if you are doing a public-private partnership. Forgetting that this provides a very easy way of government to do infrastructure, but it requires discipline. You can't enter a 25-year agreement without anticipating things that could happen in 25 years. So you need a first-class lawyer, a first-class accountant, a first realtor to think of what will happen over 25 years. Once you sign the agreement, that is it. But we believe that after signing the agreement, you can wake up on national television and say the agreement is hereby revoked. And that's it. That's it. I will just share, economic development is very critical. Lagos Ibadan, we were the concessionaires to approve our design. Took 2.5 years because there was nobody in the ministry that had an experience of how a toll road should be. Finally, it was approved. Then we invited our financiers, Land Bank, all the 35 expatriates who had worked on it for 2.5 years. We invited them for a meeting with President Jonathan. They made a presentation to him, and he was so happy. And after the presentation, he said, my brother, continue your work. He held my hands to his room. 3 weeks later on television, the project has been revoked. So this lead consultant coming from South Africa, and I said, project has been revoked. He said, where is the letter? I said, I've not seen the letter. I saw it on television. He said, Wale, this is anarchy. Now, we were building a road with 7 overhead bridges, and our total cost was 112 billion. Today, the express road today is 40% or less of what we're trying to build. It has no overhead bridge, and it has already failed because it was not well thought out. All they did was overlay the 1977 road. Since 1977, 6 new towns have emerged on that road that you have to link up and protect. There is no design for that. Now, the pain for me is that a young boy growing up in Nigeria who doesn't have the fortune of going out thinks that is an express road. It's a Bolekaja road. There is nothing express.
Dr. Babalakin, you've done, I was tempted to directly request, because I know there are many examples you could speak about, including, but fortunately you have spoken about one.
No, I will give you one other one. A deputy director was attached to us, and we were in South Africa for weeks. I mean, that was the first time I saw design being done in the public sphere. They were drawing the road and saying, look, this village has this number of people. In 5 years' time, this is what will happen, and it will cause a congestion. So we have to put a 1 kilometer road here with a small bridge. They were designing it in such a way that you could understand. So we now wanted to show off our own man who came with us from the ministry. He was a deputy director. When he finished, they told us that he won't be a pupil engineer in South Africa. Pupil engineer. So you have a system where you have inadvertently or deliberately created ignorance, and incompetence. And mediocres are now on rampage. Thank you.
Thank you very much, sir. I think we would begin to round up, and in doing so, I will ask for closing comments from all panelists, starting with Dr. Chinyere Almona. And I would suggest that she speaks to policy reversals, because that's a manifestation of the absence of rule of law, and that relates to what Dr. Babalakin just spoke about. Breaches of contract by public agencies, or breaches of understanding, and how the private sector, how businesses that you represent may perceive, or the impact on them of such things. Yes.
Thank you. So all the items you've mentioned speak to lack of predictability. If a businessman or an investor who wants to get into a 20-year capital project in Nigeria, for instance, we need to build a business or financial model and assume certain things, maybe assume the policy environment to be in a particular way, or assume, he talked about education or the skills level, there will be some assumptions made. And once he goes into this project or starts the project and things begin to change, he's hearing things on TV like he described. He's hearing things on TV that he didn't conceptualize before. Then it makes the project not bankable. The project fails. At whatever point the project is, it's already failing. So it's for us in the private sector, it's so important to be able to predict. But that's so difficult in this environment. Sometimes we wake up in the morning and something has changed. Something significant has changed with the regulation. And so everybody's running helter-skelter. You don't know what to do, how to respond to it. And it happens so frequently. So it makes doing business so difficult, because you are almost like before you go to bed, you're not sure what was going to happen the following day. And so investors, we are looking for foreign direct investors. Sometimes we celebrate, the inflows of capital, but the problem is that the inflows that you're having, they're not really patient capital because they don't trust the environment. And so the inflow isn't translating to factories and employment and all of those. They are people who want to do short-term things, portfolio, because they don't trust the business environment. So that's the risk that we face. That's the cost of the environment that we have today. Now, what will I want? I want a situation where perhaps there's a way to coordinate regulatory, issues. And changes shouldn't be arbitrary. So there has to be a process before you change a policy or a guideline that affects business. In fact, you need to do a regulatory impact assessment. How will it affect? When we were discussing this 4% with custom, the business, the manufacturer is saying, this is how it will affect us. The custom people are saying, but we haven't covered our costs. We need to charge you. There's no articulation. Clarity. There's not even the clarity. There's no understanding of the role that they're supposed to play to promote businesses. So that's the problem. So when they don't understand it, they think that it's just, let's charge this or let's charge that. But you need to think, how will it affect businesses and how are we all going towards pursuing economic development or not? So that's a big issue. Now, the other thing is the lack of transparency is so difficult to understand. Why did we do this? Why did this change occur? Every time we call some of the agencies to come talk to our members at the chamber, we find that things keep changing. When did it change? How did we not know? There has to be a process to change, to have the conversation for any of these changes to happen. But these days it happens because but there's no repercussion. Yeah, everybody can just do whatever they want. So we want to be able to predict the regulatory environment because that's the only way we can do business and do business well.
Thank you very much. Thank you very much, Dr. Almona. Let me take Bismarck's closing comments, and just like with Madam, I will ask for your recommendations related to the subject. How can we improve certainty regarding policy, environment, regulation, and the laws in relation to the business environment in Nigeria? Bismarck.
Yes, Yemi. I think that one, I must refer to what Dr. about 2 decades ago. The level of discourse, that's what the level of discourse in Nigeria has become so pedestrian, so mediocre, that we've accepted that as a new norm. The lack of thinking also has become, like Dr. Babalakin used to tell me, he said, the unthinking answer. He used to use that term. Or the unthinking, people just answer. So when we now say that, take it from 2 levels, that we want domestic investment, not just foreign direct investment. The word foreign direct investment is kind of an afterthought. If your domestic people do not invest, then the foreigners will not invest. And therefore, what are we trying to achieve? The goal of having a $1 trillion economy in 3-4 years, even though aspirational, right, is far-fetched in fact that we will not get there. But we know that we will not get there, but we'll try our best to get there. Now, let us test it against certain things that have happened. In Pegasus, Dangote, in Brooklyn, that happened a couple of weeks ago. Some people talked about the rule of law, collective bargaining and all that, and some people talked about critical national infrastructure. And I looked at it and I researched into it, and I saw that what Reagan did on the 3rd of August 1981, when the air traffic controllers shut down the U.S. airspace, and he fired all the air traffic controllers and brought the military Air Force. Ever since that time, what he said was that this is critical national infrastructure and cannot be subject to whatever rules of engagement that were acceptable in collective bargaining at that time. But he took a very clear decision. Now, shutting down the refinery and the disruptive effect of it and effect on power station and all that was not, while collective bargaining should be encouraged, there are certain critical parts of infrastructure which we would have to look at: the rule of law, look at the alternatives and the anarchy that could arise as a result of this. So both at the union level, because these are the institutions of development, the unions, the traditional rulers, and all the others, the governance framework, we must have the ability to think through what we are doing and the implications on society. That is very important. Therefore, I go back to what B.O.B. said, that if the level of discourse has become so mediocre and people are going to think, and it becomes incestuous and infectious to us, that we begin to go lower and lower, and after a while you begin to accept this pedestrian level of thinking and discussing as the new normal, right? So I think that is the most important. So we go back to the education system now and the pipeline that produces these people. And if you address that, then you can address the other things about which I would say that if you have 200 million people and only 26,000 convicts, it means that this society is better than the Vatican. It means that you can leave anything on the road. You don't need any burglar proof. You don't need anything because everybody is a saint. But that is not the truth. So if 26,000 convicts in a 200 million society is what it is a reflection of, it means that your laws are broken down. It means that the enforcement has broken down. It means that the regulatory framework does not exist. It means that the thought process is so pedantic and pedestrian that it doesn't mean anything. So we need to go back to basic principles that will allow us to think properly and discuss properly. Thank you very much.
Thank you, Bismarck. I have been consulting, and we would make a slight modification to the proceedings. Senior Osinbajo. Now, not all of us can say that. I can say that. Senior Osinbajo is leaving, has to leave, and so we would pause. We would take photographs with the panelists and I guess the partners of AELEX with His Excellency, the former Vice President, and then please direct us.
Thank you very much, Mr. Chairman. Must apologize in the introduction. I didn't properly introduce Mr. Agbaje. He is the chairman of this panel. Thank you very much. So what we are going to do, so the first set of pictures we are going to take would be the discussants, the partners, and His Excellency. Dr. Akim. Angie, please join us. I hope there's enough. Thank you very much. So for the next set, I will just ask for the partners and His Excellency alone, so that we can allow His Excellency to get to his other duties today. So just the partners, His Excellency. So for the next set of pictures, the partners, His Excellency, and the representative of the governor. Thanks. Thank you very much. So, Your Excellency, you can take your leave. Thank you very much. So the last set of pictures would be the discussants and the partners. Okay. Okay, we'll take the last set of pictures after the Q&A. So let's get back to the panel session. So thank you very much, distinguished guests, for that indulgence. So we'll return to the panel session now. Okay. So,
hello, you're welcome back. And now we can take, I had taken a comment from Bismarck. I'm coming back for his closing remarks to Dr. Babalakin. Your theme has been very rich. I suspected that. I wanted to ask you specifically about bicotomy and all of those things, and the expressway, and one which I will not mention. Just as you close, reflecting on those experiences, your recommendations for Nigeria.
Let me start by what I was told 20 years ago by a very prominent man. I didn't verify it. He said the president of Egypt, Mubarak, woke up one day. He had an economic advisor who told him that for every project you tamper with, 12 refuse to come in. Don't tamper with projects again. Don't try and settle scores. Those that are gone, let them go. Within 5 years, Egypt became a destination because government will not interfere. The Nigerian experience is acutely hurtful. MA2 is 18 years old. From the first day of operation, government decided to violate the agreement and prevented us from 50% of our revenue. And we went to court in 2009. We finally won in the Supreme Court, I think April 5, 2019. And the losses are unimaginable. We are building a hotel and conference center across the road. Some minister woke up one day and said, no, and just stopped us. There's been talk that we should come back. But what are the consequences? We signed with Intercontinental, Crown Plaza. We paid serious sign-off fees. Now, we've approached them again and they said, well, one, that signature bonus is gone. Two, the design has changed, so you have to redesign so many things. And when we were building it, the dollar was 80 to 1. Now it's 1,400 to 1. Where do you go from there? Meanwhile, in their system, they know that Nigeria is not a safe zone. In 1993, we were building the Hyatt Regency Lagos in Ikoyi. May 10, after we had raised all the money, May 10, 1993, Abacha sends soldiers to drive us off. And there was nothing I did not do to try and reach him. And finally, somebody spoke to him, and he said, look, I cannot believe that a 31-year-old boy is building that project. He has some backers I don't know. That was it. So, really, the problem is deep. Now, international, which was built around 74, has to be demolished. You cannot do any further repair on it because it was poorly maintained and has outlived its usefulness. When this happens, we're going to go to 2 or 3 years of serious inconvenience in Lagos. I don't understand the rationale. Why we always just don't think of the consequences of our action. The Attorney General is left. Let me end up with this. We were the solicitors to VGC from beginning till the owner decided to leave. No government came in Lagos State that did not give us problem. Every new government, a new issue. That new issue increased the cost. We were selling 4-bedroom flats for 2 million naira. But by the time government decides to penalize you for this, penalize you for that, and nobody is thinking that from Mobile to VGC, Raji Rasaki gave 15 allocations like VGC. 15. VGC was the 16th. Nobody built. If you had followed the Raji Rasaki plan, that route would have been a beautiful estate. Nobody can build because how do you convince a bank that you want to develop a major project in Lagos where the government can wake up one day and say, for whatever reason, you are in trouble? So we have to go back to the basics. And my problem is that we don't have the workforce. We don't have the intellectual base. We don't have the knowledge base for this modern economy. What we have, we just didn't develop it. You don't have it. So I hope that the younger ones will realize it and start to change things. I always say to people, there is no wealthy man in Nigeria. What wealth when between VI and going to Ibadan you can be kidnapped? When you live in a fortress for no reason, you live in a fortress because you could just be attacked. We've not created a society. You've not. One day I went to the United States and I was staying in a house, a very big house with a large compound. I was alone. I couldn't go to bed at night. You know why? I looked at the door that I can just break this door. I didn't feel safe. That's the Nigerian mentality. That how can this be the door protecting where you live? Anybody can kick this door. But nobody has ever kicked that door in that community. Here, bulletproof door, siren, this, all to move around. We have to rethink Nigeria. Thank you.
Thank you very much. Please, a round of applause for Dr. Babalakin. I think I'll close this section with my own reflections. You know, I recall about 15 years ago, I sat down with an expatriate professor of business in one of the leading business schools. And I don't recall how we settled on this conversation. We looked for where's the ideal city in the world where everybody likes to invest. We wanted to find the attributes of that city so we could make recommendations for Nigeria. But we first had to agree on which city. Nobody was supposed to impose a city. So the two of us settled on London. I mean, we didn't have much difficulty settling on London. And why? It's an international financial center, it's an international maritime center, it's an international business center, center of banking, center of commerce, center of insurance, center of shipping, even diplomacy. And then so we settled on, we didn't have much difficulty agreeing on London. So we now started, what is the most fundamental attribute of London that made it such a center of everything? And we spent quite some time debating all the attributes. But once we settled on one, it became clear that that was why it was London. And what do you think that thing is? The law. Predictability of the law. Perceived fairness. Equitable, straightforward, enforceable, clear. And we both concluded, from different backgrounds of business, but we were both engaged in business, and we concluded very easily that that factor that accounted for London, in spite of the diminished power of the UK in global economy and everything, the fact remains that London retains its place as a favored place for people to enter into commercial agreements, to enforce their transactions and all of that. And that preserves the strategic importance of London. I'm relating that conversation to the topic of today. If we make Nigeria's laws, investment regulations, and all of that, that predictable, that perceived to be fair, perceived to be objective, easily enforceable, we can only build Nigeria into that developed economy that Bismarck Rewane spoke about, and that developed economy that we're trying to produce through the reforms that the president is carrying out, and through many of the policies that. But if we do not have certainty around law, policy, and regulation, we might diminish the probability that we would achieve our objective. So I want to thank AELEX. I think there's going to be a question and answer, but from the panelists, AELEX has ignited a very important conversation, and perhaps we will then find how that conversation can be advanced forward. Thank you very much. Thank you to the panelists, Dr. Babalakin's very wonderful reflections, Dr. Almona's reflections from the perspective of business, and Bismarck, if you can hear me, thank you very much, in spite of your bereavement, for joining the conversation. Thank you, everyone.
Thank you very much. Thank you very much. Just before the panel leaves the stage, we want to give the audience an opportunity to ask any questions or make any contributions. I will limit, because of our time, I will limit maybe to 2 questions alone, or a question and a comment, but just 2. Thank you. Ladies first. I'll take the lady. Thank you. Oh my goodness.
Good afternoon, everyone. My name is Bumi Lawson. I'm not a lawyer, but I found this topic really, really interesting, because when I think about Nigeria and rule of law, I think of 2 letters, N and O, capital. Economic development, no as well. And today we've spoken about judicial reform and structural change, and why is the law not giving us economic development? I do want to argue that even if we have a well-robust judicial system, designed system, documented and so on, that if we do not address the moral foundation of integrity, values, and justice, that system still won't work. Dr. Babalakin talked about being malicious, and I actually do wonder that when you think about Nigeria, we have 63%, arguably, of people living in poverty. We can't even register land to release capital. Are values not an issue? So I just felt that in the conversation, that was one area that was missing. That what is our values? Do we love our brothers? Are we our brother's keeper? And so on. And then, therefore, even if we have those laws, would we really implement them for justice? Thank you.
Thank you very much. Thank you. I'll take the second question. Please, could you help with the microphone over here? Thank you.
Thank you. My name is Chinyere Almona. My question seemed to be in line with the first speaker, as if we're thinking alike. I would have loved our Vice President to be here because my question, touches where he said economic development will be good if it streams down to the poor. And my question now is, what strategies can be employed to address poverty and inequality in Nigeria? Thank you.
Thank you very much. I believe
I will ask, I don't know if Bismarck is not there, I will address the question. But is Bismarck still there? We can't hear?
Okay.
Yes, please go ahead.
See, I didn't quite get it.
The question.
Okay, I said my question is, what strategies can be employed to address poverty and inequality in Nigeria?
Simple strategy one is to actually reduce the leakage. But the leakages have a negative multiplier. And thirdly, and important, is the fact that we must the frequency and consequence. You cannot have people stealing billions and nothing happens. So, one, top. Two, leakages must be consequence managed. We're doing, I'm not saying we should go the Chinese way, where people are.
Let me, Bismarck, there's a lot of difficulty, you're breaking. So please, let me address let me attempt to address the question. Okay.
There should be consequences for bad behavior in the country, and that will be way addressing the issues. Thank you.
Thank you, Bismarck. Let me attempt to respond to the question. First of all, Bismarck spoke about economic growth. Economic growth does not automatically redress poverty. So poverty, we can be growing our economy, and we did grow our economy by large percentages between 2001 and 2014. 6, 7, 10 for that 2001 to 2003, above 15% sometimes. So we grew the economy, but we didn't necessarily redress poverty. And I remember writing a critical, I was generally very supportive of the reforms of that era, but I remember writing one column in Business Day in those days in which I lamented the fact that we were creating billionaires in units and creating poverty in hundreds of millions. So it can happen. You can be growing the economy, and the person who innovates, who sets up business will become a billionaire, and nothing will automatically happen to the poor. So there has to be deliberate policies. And that's why Professor Osinbajo, why you wanted him to be here. Because he thought that there should be very deliberate policies, and that government under his leadership tried to do social investment programs. But again, you have to do social investment programs right, sustainably. So my own view is that there is no magic wand for fixing poverty. The long-term sustainable solutions to poverty come from education. The people have to go to school, acquire skills, acquire competencies, health, public health. You have to reform the public health system such that people don't fall sick and die easily without being, once they are poor. You have to build systems to empower the youth. You know, so contrary to that perspective, that there's something we can do that will just eliminate the issue of poverty, I think the real sustainable solutions are long-term solutions, getting people into education, improving the quality of public education, and so on. However, because we have an emergency, you can focus on sectors and say, what do I do about this? And government is attempting to start that process. You say, okay, university education, NEL fund, technical education, free technical schools in federal technical colleges all over the country, etc. Conditional cash transfers. If you put your children in school, we will pay you 15,000 per month. All these three things are existing policies of government. But what we need to do is then begin to look at more sectors and more solutions, because we're in an emergency and we have to deal with that emergency. That would be my own. Okay, please. Yes.
So I do agree with you that just like they say we have multidimensional poverty, that's how the solutions will be multidimensional. So it's not just one thing, there are different things that we need to do. But in addition to education and all these things that he said, I think it's important to catalyze economic activities. You need to empower people, but not just give them money. You need to get them to work. And getting them to work means creating an environment that will help them work. Today in Nigeria, it's as if the fact that you attempted to work is a problem. So if you just do small, we do this small experiment. If you go and put a chair in front of your house and put Chinyere Almona Limited, just put the chair there. That before a few hours, give them a few hours, they will come with toilet levy, they will come with that tax. You can't operate. They haven't even asked you, what do you need to be able to work? What do you need to create, an economic activity? Nobody's asking you that. Once we get to that point where the regulators, the lawmakers understand that we need to catalyze economic activities, that way we can begin to employ. If we don't have economic activity, you can't employ. We only talk and talk and talk. We won't make progress. So we have to, for me, it's, let us find ways to allow the private sector. Stop putting bottlenecks and obstacles in their way. Allow them to work. That's what you want to do. We don't want government telling us, I want to create jobs. It's not your place to create jobs. Let the private sector create jobs. Just allow us to work. So that is, for me, once you're able to do that, then the benefits, to kind of get down to the grassroots, because everybody is able to do something and earn money. If we are not able to earn money, even if they give you money, it won't be meaningful. So we need to be able to do work and earn money.
Thank you very much, madam. Thank you. And I'm sorry we can't take any more questions. It's good to see that your interest has been tickled a bit. And unfortunately, we have to close the event. But while we are drawing the curtains to a close here, we most definitely have to take the discussion outside and continue it until we find the solutions we need. So thank you very much, panelists. Thank you very much, panel chair. Please, a round of applause as they go back to their seats. Thank you.
1 minute for the discussants. We'll have one last picture. So I'll just invite the partners to join them quickly and then have one last picture. Thank you very much for the questions. Thank you to our distinguished panelists, Mr. Chairman, sir. Okay, thank you very much. Please, another round of applause for our discussants. Did you not put it to?
No need, closing remarks.
So thank you very much for that resounding round of applause for our discussants. I was thoroughly engaged and I enjoyed the presentations. I hope you did as well. And we owe one final thanks to you, distinguished ladies and gentlemen that joined us here in person and those online. So I will invite a partner at AELEX, Mrs. Tiwalola Osazua, to give vote of thanks. Mrs. Osazua.
Good afternoon once more, our distinguished guests. I know we're eager to leave and go and start with the drinks reception, but the event won't be complete until we've thanked you. We invited you here and you honored us with your presence. So it's my honor, on behalf of the partners and everyone at AELEX, to give the vote of thanks today. This afternoon has been rich, thought-provoking and deeply relevant. We've examined, hopefully with honesty and insight, how the rule of law underpins not only justice, but the very foundations of economic development. Let me begin by expressing our deep, profound gratitude to our keynote speaker, Professor Yemi Osinbajo, SAN, for setting the stage today with such clarity and depth. His reflections reminded us that the rule of law is not an abstract principle. It is a practical instrument for building trust, enabling enterprise, and sustaining growth. I would also like to say a big thank you to His Excellency, the Executive Governor of Lagos State, ably represented by the Attorney General of Lagos State. We're deeply grateful for his effort in sending across his speech, and he was ably represented. I'd also like to say thank you to the NBA president, who couldn't be here, but sent a representative in the person of the second vice president, Mrs. Bolatumi Anima Shaun. Thank you very much, ma'am, for gracing us with your presence this afternoon. Of course, our outward gratitude also goes to our distinguished panelists. Dr. Wale Babalakin, SAN, Mr. Bismarck Rewane, Dr. Chinyere Almona, and our panel chair, Sir Opeyemi Agbaje. They he skillfully guided the discussion and the conversation today, And the panel highlighted, issues that, we need to take with us and further consider. Of course, we thank all our guests here present. I'll also acknowledge the presence of Mrs. Olufunke Adekoya, one of the founding partners of AELEX. Thank you, ma'am, for honoring us with your presence. I'll also recognize Mr. Sojiawo Gbade, who was unavoidably absent. He sent his regards to us. We're very grateful. Of course, we thank our clients who are here present, colleagues, friends, distinguished members of the press. This event couldn't have been successful without you and your support throughout everything. Many of you have joined us year after year as we've had many of these lectures, you've given of your time and you've engaged with us. At AELEX, we're committed to these sorts of dialogue, and this obviously won't be the last of it. And so we welcome you all as we continue to host this event, to continue to engage with us. Finally, and not the least, I would want to say a big thank you to the organizing committee of this lecture, Kikelomo Obisheson. And I'll please like you to give them a big round of applause for all the work that they've done. Chichi Ezenwa, Munachi Odibo, Emmanuel Adebi, Funsho Ajetumobi, Gideon. We're so grateful to you all the lawyers who supported, who volunteered in different capacities. Our event planners, we're very grateful to you. Thank you once again for being part of this lecture. Welcome you to move downstairs. Our compares will give further directions on that as we have some light refreshments and drinks and continue engaging together. Thank you all so much and have a fine evening.